The CPI report. Vocal Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15. It airs on Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. You can give us a call, parents that want some advice, encouragement, and hope that there is hope at the end of the line if you fight back. My number is 276-3956, and John's number here in Des Moines is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa, and it's those issues on which we spend a good deal of time. We do this in a couple of different mission areas. One is to influence public policy as it relates to child protection issues. And one of the events here, of course, one of the areas in which we'll have to be working is in the Iowa General Assembly, because there's all kinds of laws that need to be reconditioned in order to bring about a degree of fairness. Then we work directly with families who have difficulties, as Don mentioned a moment ago, who have difficulties with the Department of Human Services. And just a word of assistance here. When we use the word advice, we're not talking about legal advice. We're certainly not talking about illegal advice, but we do not operate as attorneys. If you need an attorney, you need to hire an attorney because we are not licensed to practice law. So we're not representing you before the bar, and we're not giving legal advice as it is commonly characterized. We'll certainly give you what benefit we can offer based upon the experience that we have had in the law and what other people have brought to us. We have also an individual who has worked in these areas called Terrance, and we're going to be talking to him later on in the program. You know, at this Christmas time, at least it's Christmas time when we do the first run of this tape, there are some things that I give some thought to. And one of them is what would happen if in the Middle East, in Bethlehem, there had been created a CPS unit. Would CPS have stolen Christmas if there had been a child protection office in Bethlehem? I believe that CPS could have stolen Christmas. I wonder what the narrative and the assessment reports might have read. A teen mother-to-be was found in a cowshed about to give birth. The underage mother said that she tried to get safer quarters, but they were not available. The surroundings were extremely poor, and there were animals nearby. The crib area was nothing but a feeding trough with straw in it. She was accompanied by a young man she claimed was her intended husband. She told this worker that she had walked most of the way to get to Bethlehem and rode a donkey partway. She admitted that she had had no prenatal care and did not have a doctor. When asked about her family, she mentioned a cousin named Elizabeth. She reported to this worker that Elizabeth was up in years and had recently delivered a son. She did not talk about other network support people. The young mother said that she was a virgin. She told this worker that the father of the child was uh, uh, not the one accompanying her in the stable. The mother of the child has not made appropriate choices in the company she keeps and in the care that she sought for herself and for her son. The teen mom has limited family support and is unable to attend adequately to the care of her infant child. The utterances about being a virgin mother leads us to believe that the unfortunate teen mom was suffering from a serious mental disorder. It is for this reason that the child was referred for a comprehensive program of counseling. It is obvious that the safety of a newborn in this environment cannot be guaranteed. It is recommended the child be removed from this couple and placed in intensive foster care, and that adequate services be made to the mother, and that Mary and Joseph have supervised visitation. The abuse is denial of critical care of an infant, a child under the age of 2. In a later narrative assessment addendum, someone noted that the child, Jesus, increased in wisdom and in stature and in favor with God and man. Apparently, he had been returned to his parents in the meantime, and there was an addendum to the report which stated that the mother and the boy's stepfather had fled the jurisdiction to escape an edict which would involve doing away with children under the age of 2. In another incident, an assessment was prepared because the report there was a report of further denial of critical care. At age 12, the boy was referred to this worker. The boy's family had traveled a considerable distance to attend a large church conference. The families who attended traveled in a caravan, and when the conference concluded, the parents failed to make certain that the child was in the caravan. It was reported the family did not discover the child's absence for 3 days. This meant that it took 3 days to retrace their steps and yet another day to find the boy. He was found in the temple talking to the intellectuals. This is not an age-appropriate activity. A child of 12 cannot be safely left for 7 days in a strange city without funds, without food, and without adequate supervision. The violation is denial of critical care and failure to protect. So isn't it a shame that we didn't have a CPS in Bethlehem? On the other hand, if the CPS had stolen Christmas, wouldn't that be a shame for the merchants of today? Nothing to sell, nothing to buy, no money changing hands. Well, something else comes up at Christmas, and that is the birthday of a marvelous young lady by the name of Jody Harvey. She was Jody Harvey until she was married. Her name is now Jody Cabrera, and she is a resident with her 2 daughters of the city of Ankeny. She has a birthday on the 12th of December, and that was some 38 years ago.
Happy birthday.
If this is Sunday, I'll have to say happy birthday on Wednesday. If this is Wednesday, I'll have to say happy birthday, Jody. Don't get to do that very often, maybe once a year.
So what day is her birthday now?
Her birthday is on December the 13th. Did I say December 12th? December 12th is another important anniversary, but it isn't connected with Jody. It's connected to our relatives. So happy birthday, Jody, on the 13th of December. Happy 38th. I hope I have calculated that correctly. It's been a few years. Don, there's been some grassroots efforts that are quite interesting. There's been some judicial things too that have been rather interesting, and we need to pat some judges on the back for coming up with something profound and seemingly something with a degree of wisdom to it. And I think that when wisdom and judges go together, we ought to make a big celebration out of that. One thing that I think that should happen in every office, on every desk of every socialist worker in the state of Iowa, is this picture right here should be posted. You see, Shelby Dewis did enjoy Christmas, apparently, but she didn't quite pull through New Year's because it was on the 4th of January that her body was found beaten, battered, but they can't find who it was that did it.
You sure she enjoyed Christmas?
Well, she doesn't look like
it.
Doesn't look like she's enjoying much of anything here. Pretty unhappy little girl. I also read an article, a short article, where Vilsack had everything all taken care of because now he had signed into law a measure whereby boyfriends and relatives and so forth are to be kept away from children. So just pass another law. What this did was it expanded what was otherwise child endangerment laws, because it used to be that a person who was not legally responsible for caring for a child was outside of any law having to do with child endangerment. But he was such a good lawmaker that he was able to sign into law something that would help protect children. Well, I'm not sure that this little girl was protected, nor did any of those laws protect other children who have died since then in child abuse situations, and in situations in which the DHS had already intervened. We have one case in Cedar Rapids where Bentleys were hanging around the family. Well, they will be going to trial, of course, on charges of murdering a child there. Well, are they really doing what they should be doing for the families of the state of Iowa, or are they practicing some efforts and activities and expenditures in great numbers in a counterproductive activity? In just a little bit, we'll be talking to Don about some grassroots efforts. Don, what have you read or what have you seen coming about in calling for class action suits against the Department of Human Services, attempting apparently to correct some of the hazards, some of the suffering that DHS has left in its wake? Don, tell us about anything that you've seen about class action.
Okay, John. I know of two that Iowa people can join. One is here in Des Moines and one Oklahoma. The first one, a class action lawsuit is being started with a Des Moines attorney. Anyone that has problems with the DHS is encouraged to attend a meeting coming up. This class action is directed at the Iowa DHS. This class action will be filed in Polk County, but anyone can join the class action with Iowa DHS problems. The next meeting at the attorney's office in Beaverdale, that's on north of Drake University a little ways, here in Des Moines, will be on December 16th to work out some of the details. Did you want to put that on the screen, John?
What?
Anyway, this one will involve both the loss of the children to the DHS, but also the elderly that has had problems with the DHS. A phone conference call will be available to those that live a long way from Des Moines. There's also a second major class action. It started in Oklahoma in September, and it went very fast to the United States District Court in Washington, D.C. Your only cost in this action is the time, paperwork, and postage to mail your paperwork, plus a donation to help the main people that file the documents. A notarized affidavit is needed along with a joinder. So we're talking about something like 5 pages of your paperwork, and then you have to run about 12 copies to send into the courts in one other place. So 12 copies of whatever you send in. The Oklahoma class action encourages everyone that has a denial of due process. This is basically anyone that had a problem with government and the court, but most of the people that sign up have problems with DHS and the court. If you're interested in the Oklahoma class action, there's a website where they keep people updated on what's going on and how to file your action, and there's telephone number you can call to be on a conference call at 8 o'clock in the evening our time, and you can participate in there or just listen to get an update. And John was pointing out the website, uscdc.org/familyrightsradio.htm. For those on Google, you can type in Family Rights Radio and find it that way. And you'll find a wealth of information on that website. If you want to contact me, you can give me a call at the telephone number we'll have at the end of the program, or my email address is Donnieburg, DONNIEBURG, at mchsi.com. Okay, John.
Okay, so a couple of grassroots efforts here.
December 16th, I'll repeat it again for the Des Moines class action here in Beaverdale at 1 o'clock in the afternoon.
Yeah, we had this photographed real well. We just didn't get it punched up on the air early on. So I want to thank you, Don, for bringing attention to these two class action suits. It's kind of interesting what happens in class action. In fact, there is already a class action suit in the district court here in Des Moines with an outfit called Microsoft. It'd be interesting to see what happens to the hundreds of millions of dollars that are being asked out of Microsoft, whether or not these people, whether Microsoft users, which number quite a few in Polk County, are going to get reimbursed for any excessive costs that they have. I haven't heard a lot of complaining about Microsoft costs. It's pretty good software, and I think we would be in real trouble if Microsoft would say, well, if you guys don't like us, if you're going to sue us, we're just not going to support anybody in Iowa with Microsoft products. I think that would be pretty tragic situations. Well, one thing that has happened in the courts is there's if you look hard enough and long enough, you will find wisdom somewhere in the opinions written by the justices of the Iowa Supreme Court. It might take a while to find them. It also shows us the lack of wisdom of the judges in the district courts, because for every piece of wisdom and reversal in the Supreme Court, it means that somebody loused up with the law at the district court level, right? Well, just to be sure that I know what I'm talking about here, let's refer these questions to Terrance Walker.
Well, thanks again, John. And yes, I am the judge of the judges, and I think you touched on an excellent point there, that sometimes you can actually find an opinion with that actually has some wisdom on it coming out of the Iowa Supreme Court. And I think a lot of that has to do with the shuffling up of the Supreme Court in the past several months. One of them retired, didn't they, Liverado, and there was another judge that was appointed, and there was another judge that was appointed last year in another judge's place. So I think that makes a huge difference. You got some new, fresh faces in there, people that have a fresh look on things, and sometimes the old guard, as it goes to say, it loses kind of its way. But we've got an excellent opinion that came out of the Iowa Supreme Court on the 4th, I believe, and this comes out of the Des Moines Register website. And it basically is regarding man's probation. A lot of times judges will do probation, and they'll have extra conditions as a part of the probation. Sometimes they do some outlandish things, and in this case the judge went too far, I guess. And I'll just go on to state the justices in the Iowa Supreme Court made the ruling. They scaled back the power of probation officers last week by ruling that a Polk County judge overstepped her authority in approving sex-related conditions on a Windsor Heights man's probation for drunk driving. The justices made the ruling in the case of Christopher Valin, 33, whose criminal history includes a 2004 conviction for drunk driving and a 1999 conviction for assault with intent to commit sexual abuse. Valin was sentenced by Judge Cynthia Moisen to a suspended prison term and 2 years probation for the drunken driving offense. He objected when that probation ultimately included conditions related to the earlier sex offense. Court papers say Moisen initially rejected a plan by the Correctional Department to limit Valin's contact with children because there was no evidence that Valin posed a threat to children. Court documents say the 1999 arrest involved an adult woman who Valin fondled after he consumed too much alcohol in college. But Moisen declined to stop probation officers from requiring that Valin complete sex offender treatment and undergo what is called a penile plethysmograph test. I hope I got that word right.
Plethysmograph,
The test is commonly used with sexual predators to measure sexual arousal. Isn't that one where they show them a bunch of crazy pictures,
yeah,
and they have them hooked up to some device? I don't even want to imagine what they do.
For men, they show women's pictures in the nude, and I assume, for women, they put up men's pictures in the nude, which is illegal for us, but they seem to get by with it. Pornography. Even for the falsely accused, they smear the pornography in front of the falsely accused. That's my opinion on false accusations anyway, Terrance.
Yeah, that's crazy. On Friday, the Supreme Court justices ruled that there was insufficient nexus between Valin's present conviction and special conditions of probation. State officials may use history to justify the strings attached to probation. The justices ruled, excuse me, but there must be recent facts to justify those steps.
Did you catch it, Terrance?
Oh my goodness, I think I got some allergies here. In other words, there needs to be a reason to believe that those steps would solve a problem for the person on probation or would protect society at large. The practical effect of a policy that automatically requires sex offender treatment, quote, is to treat Valin as a current sex offender solely because of his prior offense, the court wrote. Such a policy has the effect of imposing greater restrictions on an offender than reasonably needed to achieve the goals of probation for the given crime. So there you have it. That is a good opinion. That's one that actually went in favor of a defendant, which is rare. I'm glad that they scale back. I mean, those are heinous crimes that he did. You know, I'm sure assault with intent back in '99. But there is such a thing called the United States Constitution and the double jeopardy protections of the Fifth Amendment. And so, I mean, they can't go back after the guy's already served his time or his probation or whatever for his 1999 conviction, and then go and say, well, we want to make you suffer some more for drunk driving in 2004 by revisiting your 1999 conviction, and let's see if you have some weird intentions, you know, in your head, and hook you up to a penile plethysmograph and show you all these dirty pictures of women and probably children and animals. I don't know what they do, but it sounds kind of weird. But anyway, that's my 2 cents. Did you have any comments on that, John or Don?
I thought it was an excellent decision, especially in the opinion itself, where it said that the Department of Corrections, being an agency such as it is, cannot do just exactly what it pleases, that it must operate within boundaries. And of course, they'll come back and say, well, yes, but we had discretion. And the court comes back and says, well, yes, even discretion has boundaries.
Yeah.
I think that this will be a very useful opinion in other cases. I think what you're going to find, however, in something that is as grand and as glorious as this decision, you're going to find that they will not, they'll make it per curiam, which means it can't be used to cite in other cases.
Yeah, they'll just do like
it would appear to me that it would be wise, however, for them to put this in Westlaw so that it can become a precedent setting type of thing, and that agencies can be held to some degree of reasonableness in what they do. That just because you're an agent of government doesn't mean that you can do anything that you please. I think this has some implications for a department that we've been working with, Terrance.
Yeah, the DHS. Now that's interesting you say that accountability, because I was getting ready to get to that topic because last time I was on here, I think that there was a measure. Well, I know there was a measure in South Dakota that was on the ballot November, and the state of South Dakota in regards to judicial accountability, and the organization was jail for judges, Judicial Accountability Initiative Law. They was trying to pass the measure, which was actually petitioned upon this past summer, and actually last fall, where they gathered over 43,000 signatures to get a measure on the ballot up there for this past November, which basically would have scaled back judicial immunity, and it set forth 7 different reasons in which a judge could be sanctioned and not only sanctioned but removed and sued because of violations of law or fraud or anything that they did that was intentional in relation to a person's rights, and and not only that, but if they did something to intentionally violate the law. Well, the backers of the amendment, which was Amendment E in South Dakota, were successful in getting the measure on the ballot. However, Attorney General Larry Long craftily worded the ballot for the measure in South Dakota, and even though the measure specifically stated it was limited to judges, the only thing that they put on the ballot in South Dakota this past November, which was last month, was that the measure applied to school boards, it applied to various other administrators and other kind of officials in a judicial capacity. Well, the measure did not explicitly state anything in regards to any of these other bodies. So what happened was, and they did this very skillfully and very craftily. They got the teachers against Amendment E by using this wording. They got almost all the unions that have teachers in them against Amendment E, and a lot of the various other bodies of government, the other governmental body unions that are like ACME, all of those organizations against Amendment E by using this deceptive and misleading wording, which is a lot of times what's often done but not discussed about in law by so-called legal professions, rewording or miswording and using deceptive words to describe something. So, and you wonder how it is that we get to this notion that the judiciary likes to use, that they don't want to be influenced by special interests. Well, when you got the teachers unions, the banks, and all of the other special interests backing something that's against judicial accountability, that is, in essence, supporting and being influenced by special interests. And I thought this was interesting. I just pulled this up today. I've been following this for a while. I'm a busy man, though. I actually have a business to run. But I just pulled this up today, and I thought this was interesting because it shows a list of the donors that would back Amendment E. And if you could see, look at all these individuals here. The 10 top donors. Now, if you look, there was one gentleman in particular. He's actually the head of the movement, or he was the head of the movement in South Dakota. I think they might continue to the next time, but he contributed over $54,000 out of his pocket, and then gave another $110,000 in loan to support this. This is a grassroots effort. So again, we go back to grassroots efforts. I think that's important. Now look, the next level is 6,000, then the next level is 1,000, and then the next level under that is 300. So the majority of the money was contributed by one man. As far as we could see, as far as the top 10 donors are concerned, it might have been hundreds of people from all over the country that gave, like 10, 20, 30, 40, $50. Now look at the people that didn't support Amendment E, that actually went against Amendment E. And if you look, the top donors: National Association Mutual Insurance Company, Citibank, ExxonMobil, Wells Fargo, First Premier, Dakota Bank, First National Bank, Core Trust Bank, Bank West, Woods, Fuller and Schultz, the law firm. And these people all gave $20,000 or more. Now, or these organizations, I should say. Now, these are supposed to be, if we're to be taken by all the rhetoric that actually came about before Amendment E, then we would have to be led to believe, if we accepted what it was being said at face value, that we don't want special interest groups to affect the judiciary. That was the judiciary stance, not only in South Dakota, but by a lot of these press releases that were coming out, not only from judges here in Iowa. I think Lavarado had something to say about that before he retired, but former judge of the Supreme Court, Sandra Day O'Connor, she said something about, oh, well, we don't want to be influenced by special interest groups. Well, here we have on the ballot a measure that was largely supported by grassroots people, a measure that people had gathered over 43,000 signatures to support, and the judiciary comes against it on the basis of special interest groups being for it, when it's real people that were for it, and there was no organizations. As you can see at the top donors list, mainly individuals. And then when they back the when the people that are against the amendment, are all special or groups like banks, insurance companies, law firms. What is that? Those are special interest groups. So, here we have double talk, which makes absolutely no sense. But, it just goes to show you what we're up against and what special interest groups they are okay with being influenced by the people with the money, or the organizations and the corporations with the money. So next time, I think that when we have an amendment like this go to, one of the states, or actually to the United States as a whole for accountability of the judges, I think that this sheds a whole new perspective on what special interest groups are actually doing in relation to the judiciary, and so that they can't come against the grassroots organizations and the grassroots people such as ourselves and say, well, we don't want a measure like that because it's supported by special interest groups. Because, hey, the banks, the law firms, and the other major corporations, those are all special interest groups, trade organizations, trade unions. All of those obviously have a hand in what's taking place there. And, because of all of this misrepresentation and big corporate money, here we have a measure of the people not only being defeated, but being soundly defeated because of the deception and the amount of money that was poured in to go against the actual campaign. So that's what happened here in November, just to give you an update. But what does all this mean? I think that this next time we'll be better prepared, and I hope that there will be some other states that get on board. I will definitely contribute some work, some effort to get some resolutions passed in that regard. And one of the other articles, did you have some comment on that, John, or Don?
Not at this point, no.
Okay. I think this goes back to there was one gentleman that is actually affiliated with jail that made a good point. And it was kind of eerie because he cited Stalin. And Stalin at one time it said about democracy, he said the decision of the vote is not cast by those, it does not count by those who cast the vote. It's determined by those who cast the ballot. And this is a prime example of why democracy and how democracy is not working. And it's sad because I believe in democracy, but when you have a government such as the one in South Dakota, and the Attorney General up there, Larry Long, who's willing to change the wording of the actual measure in order to get it defeated, I think that says a lot. But yeah, the actual quote, Don just pointed this out to me, by Joseph Stalin is, "Those who cast the votes decide nothing. Those who count the votes decide everything." And of course, South Dakota Attorney Larry Long had already decided this was a measure that they were going to cast in a negative light on the ballot, and therefore it was soundly defeated. But I think that they're going to be more prepared next time, and I'm willing to say I'll bet that there'll be another measure within the next year or two on one other state's ballot, and I'm sure that will pass. But did you have any other comment? I think that's about it that I have to say on this show for today on the judges.
Okay. Good enough. Well, thank you for that report. One other thing, we're going to be talking about empowering fathers here in a moment, or maybe not empowering fathers so much, because they already have plenty of power. It's just that that power has been diminished by public policy. that sort of makes them second-rate citizens. And the only reason why we give any consideration to fathers in families that are broken is that they can nail father for child support. They don't have to keep track of his address in order to give him important notices, court notices of hearings and so forth, when he's thrown out of the home. But they certainly know where he lives when it comes time to assess child support. Do they not? Well, you had some involvement in that business of involving, and you had a good court case, a good court decision. You want to tell us a little bit about your involvement as a father and how they honored you, recognized you as a father, the Department of Human Services, Terrance?
Well, I had a case here just about a little over a month ago, actually a month and a half ago. The DHS in Story County had, because of the mother of my daughter, had taken temporary custody of my daughter, had her basically signed over to temporary custody voluntarily by the mother, without my permission and without my knowledge, of course.
The mother is not living in the home.
Mother was not living with me, no, and we have not been together for some 12 years. But the eerie thing is that there is a law on the books, and it is under 232.79A of the Iowa Code. And now the mother was arrested, and 232.79A says if a child does not have adult supervision because the child's parent has been, and I'm paraphrasing this, has been arrested and detained, and that no adult who is legally responsible for the care of the child can be located within a reasonable amount of time, the peace officer shall attempt to place the child with an adult relative of the child. Now, that was done temporarily. However, shortly thereafter, the children, or my child was placed in temporary foster care without my knowledge. And I thought that was blatantly illegal under the law. And not only that, their own documents, I'd done an open records request on the DHS, their own documents said make sure that you know, are able to contact the parents and let them know of the situation, both parents. And that wasn't done. Under 232.79A, again, it says the placement shall not exceed a period of 24 hours and shall be terminated when the person who is legally responsible for the care of the child is located, takes custody of the child. That wasn't done. Nobody had attempted to contact me. The mother knows my whereabouts, knows my phone number. The daughter knows my whereabouts, knows my phone number. So, I mean, there's really no excuse. You know, I think that the funny thing was when I found out, and I found out through the grandparents, the maternal grandparents of my child, that the mother was in custody and that my daughter was in foster care custody. I was like, well, what the heck's going on? I called the lady that was supposed to be responsible. It was on a Sunday, so of course the DHS office was closed. Monday, I called again. Busy. No response. About 8 o'clock, I figured they'd open at 8, so I call at 8. You know, leave a message. How do I get my child?
That's all you got was a recording?
That's all I got recorded. Well, and then I called at 9. I said, well, you know, is this lady in the office? Oh, yeah, but she's busy. So I leave another voicemail. Same thing happens at 9 o'clock, 10 o'clock, 11 o'clock. So 12 o'clock, I go over to the office, which is in Ames, which is like 30 minutes away from where I live. And I sit there for 45 minutes, me and a friend of mine. And, you know, the funny thing is that they can't provide us any answers to my one question: how do I get my daughter? How do I see my daughter? I was supposed to see her that weekend. I have visitation, and I have joint legal custody. I had joint legal custody at the time. Then, so the lady walks out 45 minutes later. Stacy Pratt is her name. And I'll never forget this. She just says, "Hi, Mr. Walker, and I gotta go to some other thing." You know, that was it. That's all she's gonna offer. I said,
That's
well,
how they handle
I said,
children.
yeah,
They
I
fall
said,
through the
well,
cracks.
I said, well,
My goodness.
what kind of sense does that make? And you're gonna walk out when you have my daughter and you have her against my will without my knowledge? You know, come on. Now, I expect a lot more than that from state government, and I expect a lot more from that from any decent person with common sense to know that a father, a natural father, would be kept out of the loop and not have no concern or no right to know. You know, come on. It just doesn't make any sense. So she is walking out, and then what was really bewildering was there was some lady that happened to think that what I was asking, the one question I was asking, was unreasonable. And she said, "Well, I don't understand." I said, "Well, lady, this is my daughter. What are you talking about? I don't understand why I can't get an answer to my one question." And so at that point, my friend had seen I was probably gonna get the runaround, probably gonna get upset. So he just intervened and said, "Well, he said, folks, this is a man that only has one question. He wants to know where his daughter is and how to get her, and and you guys are giving him the runaround. Can you give him some information? And because otherwise it's going to be a liability issue." And lo and behold, it is a liability issue, because I did find an Eighth Circuit case that says this, and this was a 2005 Eighth Circuit case. August 12, 2005, guy by the name of Kenneth Harold Swipes. He had basically had his daughter taken from him. Now, this was a little bit different situation, but still the same rules apply. A deputy had took his daughter from him and gave him to the mother for some reason. I don't know. They had some custody fight or whatnot. But he had basically not been given a hearing for a while. I mean, it was like 3 weeks. And this is what the Eighth Circuit said. They said, as a matter of law, a parent should not have to wait 17 days after his child has been removed for a hearing. And that's exactly what they said. Now, I filed for a hearing the next day, actually the same day in Polk County, but they told me I got to go back to Story County to file something, which I did which was the 17th, which is like 6 days later, after the mother had basically filed a voluntary placement for my daughter after she got arrested. So I didn't get a hearing until like the 30th, which was about 19 days later. So again, it does become a liability issue because, like the Eighth Circuit says, and I'll quote it again, it says, as a matter of law, a parent should not have to wait 17 days after his child has been removed for a hearing. And that's the whole thing. So, Stacy Pratt, you got a surprise coming for you. I just want to let you know. We warned you. It was a liability issue. It is a liability issue. It's a violation of due process rights. 14th Amendment costs a lot of money. So, be prepared.
So do you know of a time frame that actually the law does say that you have a right to a hearing on?
Well, there is a state law and then there's federal law. Of course, the federal law, is kind of vague and depends on cases or whatnot. Sometimes it's clear cut, sometimes it's not so clear cut. But when you have the Eighth Circuit, which is the controlling federal circuit over this Iowa district, then that law, their reading of the law as it pertains to DHS matters is controlling. So, but they're supposed to notify you within 24 hours. They're supposed to be trying to locate the other parent. so that they can take custody. In this case, this was not done. They tried to, it seems like they did more work and effort and concentration trying to take my daughter and put her in foster care. And then, even after the fact, when I went and got her and filed for temporary physical care, they still was recommending, and these are open records documents that I found, they were still recommending to the county attorney to file a China petition to try to take her. So it's bewildering. The DHS is doing these kind of things. You know, I can understand protecting the child, but when you're trying to take the child from a father that has nothing to do with what the mother got arrested for, I mean, it doesn't make any sense. You know, these people should be thrown out. I mean, you know, if the shoe would have been on the other foot, you know, if I'm taking somebody's kid and not telling them nothing, you know, I'd be under the jail. So I mean, I think the lady should be fired or something at the very least.
You mean,
you know,
you said
Stacey
that?
Pratt? Yeah, she should be fired. You know, why would a person in their right mind, you know, take and want to put a child in foster care when the other parent is functional, has their own business, has another child that they've had in their own custody and raised from the time they were infant to 11 years old? I mean, come on, you know, you're not even thinking. And you don't even have and to say that you couldn't find me, come on. You know, my daughter's 13 years old. She has my number. She calls me all the time. You know, it doesn't make any sense. So there's no excuse.
After 20 years of experience, personal experience, it doesn't surprise me, Terrance, what you went through.
It doesn't make any sense, man.
I saw it 20 years ago, and I've talked to a lot of parents, and that's just the way DHS operates. It's a money scheme, for one thing. If they put the child in your hands, the money trail would stop. But if they can throw the child in foster care, the money flows very good, and they have a job.
And the thing that really insulted my intelligence is that when I filed for temporary custody or temporary physical care, I've got joint legal custody already, but when I filed for temporary physical care, the next day, the lady that shows up at the hearing next to the mother is the temporary foster care lady. And what are you arguing, lady? You're arguing that it's best for my daughter to be in foster care? Are you crazy? You know, come on. You know, would you put your daughter in foster care? No. Okay, rest my case. You know, and she had the stupidity to get on the stand to allow me to ask her that question because, you know, what is she going to testify to? That foster care is good for children? Come on.
I think they have that weird concept in the back of their minds that there couldn't be that you couldn't do a child a greater favor than to put him under the control of the Iowa Department of Human Services, and of course we have a different way of thinking of those things. There was one other issue that may have come to your attention of a judge, a district court judge that was sentenced. Do you recall that story, Terrance?
Yeah,
and he's complaining about his sentence.
Yeah, if I can just dig out that story. I think I lost the story here.
Okay.
You mean a judge is human, that something could go wrong for a judge and he'd complain?
Now, this is a judge I think we talked about last year.
Right.
Actually, a little bit the year before.
Is that the one that retired?
Yeah.
Oh, well,
Judge Weaver. You still have that case?
Things went so good for him, didn't it? So he could retire.
It was Judge Weaver out of, what was it, Muscatine?
Burlington, yeah, Muscatine, I believe.
Muscatine County or something like that. Yeah, got...
the judges stick together, so they give him
removed from the bench, and you know he shouldn't be complaining because he's getting 65% of something like that of what he was making when he was working.
He didn't think he should be sent to prison when he made a plea bargain. You know, he didn't think he should be sent to prison for 2 years for second offense OWI. Now, I thought about him when I read that other story about Valen's story, because Valen says, yeah, judges are given some discretion, and the discretion has boundaries. Well, within that boundary was a 2-year sentence. Well, this judge thought that he shouldn't be, that the judge that was sentencing him shouldn't be able to operate within the boundaries of his discretion.
Oh, here is the story.
Now he'll win if he can demonstrate. He'll win if he can demonstrate that the judge exceeded his limits of discretion. Okay, go ahead.
Well, it says that he was convicted of drunken driving, and this was like his second drunken driving charge,
Right.
and it was in November '04, and he pleaded to guilty and sentenced in '05, April '05, and up to 2 years in prison in order to complete an alcohol treatment program. He was ordered to report to the residential corrections facility. Then he appealed, arguing that the district court abused its discretion by saying it would not be bound by the plea agreement, but did not allow him a chance to withdraw his guilty plea. And the funny thing is, he said he wasn't informed that the court could impose a sentence less favorable than the one provided for in the plea agreement. What is he going to argue? That he doesn't know that the court doesn't have to be bound by the agreement of the county attorney and the defendant?
He's pleading
When he's a judge?
incompetence.
He must be pleading incompetence. There's a lot of ones out there, I guess.
You bet.
But I think that's kind of an argument that's going to get tossed by the wayside, or it should be, because he can't reasonably argue that he didn't know that they don't have to be bound by agreements between the parties. They're bound by what the statute says. I know that. A district court judge especially should know that, especially since they've been practicing since 1984.
Right. Is there anything wrong about judges being held to the same sentencing standard as peasants?
I do have to give him one kudos, though, because it's the first time I can see that a judge has ever admitted incompetence. Because that's what he's admitting is incompetence. If he says that he did not know that the judge is not bound by agreement between the defendant and the prosecutor.
You bet.
So I got to give him a thumbs up on that one.
You bet. Okay, here's a couple of numbers that may be of assistance to people who are having difficulties with the Department of Human Services. We might be able to offer some hints that would be helpful to you. And there's something else that you need to know, and that is how to contact or how to get started on knowing something about the Department of Human Services. Here's their website, www.dhs.state.ia.us. And that'll give you, you can look up appeals and determine how you can resist any child abuse report that you get. You can give me back the phone numbers, and we'll get those back on the screen again. Here's those numbers again. We'll see you next week.